We're going to go back there and we're going to be asking you what varietals you might have available for sale, because we want to take representative wines from those varietals and pour them at the convention and then try to drum up some business. We've got some the brochures that we're going to pass out. We're going to try to put a video together, but you know, this is going to be an important meeting, so please think about what you might have that's available. You don't have to commit it to the people. You can sell it on a first come, first served basis. But it is an opportunity, or what an association is trying to do for its members is make us more profitable and more educated. I mean, we do that through improving our viticulture, we do it through education, but we're also strongly trying to do it through marketing.
In some of the last meetings, we talked about name tags for either some new members or existing members who have worn them out with pride. The new ones that we're looking at getting have the magnetic closure, so you don't poke a hole in your favorite sweater. Stay nice and firm on your clothing. We've priced those out. If we can get 30 people to commit to them, it drops the price down to $6.60, and that's locally out of the store in Jackson. Also, Mike, on a trip down to Paso Robles, saw some really nice grower signs. They are 18 by 24 inch dye bond aluminum signs. You can get them printed single-sided or double-sided. The quote, if we can order 20 of them, double-sided is $37, single-sided is $30.
Just to let growers know that there is an upcoming managed drought workshop in Modesto, co-organized by UC and USDA, and it's bringing in Australian and Israeli experts. It's a 2-day meeting, January 12th to the 13th, and I think early bird registration is $80, and that's before December 18th. So I have sent out a notice on that. I'll send another one out tomorrow, or yeah, probably tomorrow. And that's the most upcoming meeting that we have going.
So first of all, I just want to thank you very much for allowing me to come and speak to you tonight. This is it's a treat to come up here. It's a treat to enjoy your wine, and I appreciate your letting me come and do that. I was telling somebody, a couple people, that this room is sort of shocking when it came in because it reminds me of where I grew up, which is in northeastern Washington. I grew up in a very small town up in south of the border of Canada and west of the border of Idaho, and we had a grange where we went to every month and did potluck, and it looks exactly like this room. So I kind of felt like I was coming home. I am an employment attorney in Sacramento. I have a small firm with a couple other partners. I've done various types of work over the years. I used to litigate and defend large employers in wage and hour class actions and single plaintiff cases, harassment, discrimination. Did that for a number of years and got tired of the litigation race. Then I went in-house. I was an in-house employment attorney with Sutter Health for a number of years, where one of the nice things about being an in-house attorney is you get to kind of partner with the business a little bit more, have a little bit more influence and impact on business decisions. After doing that for a few years, I started this firm with a couple other partners, and the focus of our practice is really on litigation prevention and trying to work with employers to avoid lawsuits, or at least if you can't avoid lawsuits, understand what the risk is that you're assuming when you make certain business decisions. But I've been asked to talk about two specific areas in the wage and hour context. And the first one is this labor code 2810.3. It's been referred to as AB Assembly Bill 1897, and it went into effect in January of this year. And as Mike said, what this law purports to do is to make businesses jointly liable for wages paid, or wages owed, and for workers' compensation insurance coverage, and some health and safety liability with labor contractors, with staffing agencies, labor contractors, those sorts of folks. All right, so without further ado, let's talk about what this law is. I prepared a handout for all of you, which you should have copies there. And what I tried to do with this is just to sort of outline what the law is, what some of the risks are, who's covered and who isn't covered, We're going to talk about one issue that isn't totally clear, and then some ideas on how to mitigate the risk around it. Yeah. So this law, as I said, was intended to extend liability to the businesses who work with labor contractors. And it was to resolve this issue where there were this class of workers, this group of workers who were not adequately weren't being treated fairly under the wage and hour laws and the health and safety laws. Now, the question is, who is covered? And this is where, I think it's particularly important, and I don't, this is where you're going to decide how many of you are actually covered by this law. The standard for who is covered by this law, the two most important ones are the ones that I've highlighted in bold here. It's employers with more than 25 workers. So if you're a business with more than 25 workers, whether those workers are employees or labor contractors, you are covered by this law. Or if you're an employer with more than 5 temporary employees or contract employees. So those two exemptions have two different purposes. The first one, the 25 or more, the more than 25 rule, is intended to provide some protection to small businesses. And the interesting thing about this law is that when it was originally drafted, it didn't have these exemptions in it. So last year when we were tracking this law, it would have covered anybody, no matter how many employees you had, or how many workers you had. But there was some lobbying and negotiation done, and ultimately these exemptions were added. So the first important exemption is that if you have fewer than 25 or fewer workers, you're not covered by this law, and you're not strictly liable for what the labor contractors' wage and hour practices are. Yeah.
Is that contract workers or all workers?
Contract workers or employees. So they use the term workers, not just employees. So it's 25 workers, whether they're employees or contractors, or contract workers. Does that make sense? No. No?
So you have a combination of, full-time employees and room employees, and then you use contract labor also?
Yeah, so if you have 15 employees, and then you contract for 11 employees, or 11 workers, you're covered by the law, because you have 26 workers. The question here.
Yeah, so does that mean workers at any one time or total workers over the year? Because if you use a labor contractor, you're never quite sure whether the guys you got this time are the same as the guys you got last time.
Yeah, that's a fantastic question. I think that's really at the heart of the issue here, and unfortunately the law is not entirely clear. So let me restate what the question is, because I think this is where we need to spend some time talking about it. Does that requirement, if the requirement is if you have more than 25 workers, does that mean that if at any point in the year you have 25 workers, does that mean you are liable for the duration of the year? Or does it only mean that you're liable during the time period that you have more than 25 workers? The law itself does not address this particular issue. There's not been any case law that's interpreted this particular issue. So I think there's a very strong argument. I think it's true whether we're talking about the more than 25 standard, or we're talking about the more than 5 contract worker standard. I think there's a very strong argument that you can only be liable under the law when you are actually covered by it. So the question is, your labor contractor has 30 workers. And over any period of time, while you may never have more than 25 of those workers on your premises, all 30 of those may at some point in time come through your doors.
And it's possible that my labor contractor never has more than 25 at any one time. But if you total up all the guys who work for him throughout the year, that number may be over 25.
Yeah, but the question is, do you ever have 25 workers on your property doing work for you?
Right.
And if the answer is no, then you're not covered by the law. So make sure I have the question right. So the question is, if you have 10 at one time, and then you have another 10 at another time, and then you have another 10 at a third time, is that going to bring you over 25? Or is it, do you have 25 at any one time?
No.
And the question, and the answer is, my understanding of the law is that the issue is whether you have 25 workers on your property. It's not an issue of whether you have more than 25 over the course of the year. I see you had a comment.
I'll skip this one.
So
if you have a winery and you have a base set of people who are your employees, who you've not terminated, it's still, and then you have some contract laborers on your property, it's still how many people are working that day? So that on any given day, there's not more than 25, you're okay?
yeah, so I mean I think that's, you know, if you can manage your workforce so that you never have more than 25 workers, I think you can avoid liability under this law.
On any day showing up?
Yeah. But the issue is if you have more than 25 workers at some point, what liability are you going to have for workers who, for example, continue on your premises for longer than the one day that you're over on the law? The second one, so the question is, what about the second exemption that's listed there? The one that says that if you use 5 or fewer contract workers, then you're not covered by the law. That's designed to benefit those employers who have more than 25 employees, but they use fewer than 6 labor contractors. So it's designed to protect those employers who may have 100 employees, but they only have 5 or 4 contractors.
So the critical distinction is the temporary employee concept. That is, you might have regular employees under the 25, but in the second category, it's the temporary status.
Yeah.
I understand.
Yeah, exactly. The question is, given the reality of being an employer in California, if you allow 1 or 2 people to come on your property from a labor contractor, as a practical matter, you're going to be liable for them anyway. Is that basically that
That's right, absolutely.
Yeah. So this is a distinction that attorneys make, and I apologize up front. So here's the distinction, though. What's new about this law, and what I said earlier is true, is that this concept of being liable for a labor contractor or staffing agency's employees is not new. We used to refer to it under the joint employment concept, and that concept is still alive and well. What's new about this law is it imposes strict liability.
So how do you find out about how the practices of your contractor, contract labor?
Yeah. So the question is, and I've given you some thoughts on the bottom of the second page about how to deal with this law. And the question is, how do you find out about the practices of your labor contractor? So one recommendation I have and is you should look at the contract you have with your labor contractor and see what's in there already. There may already be some indemnification language in there, but most of us attorneys are recommending that you have an indemnification, a strong indemnification provision in your contract with your labor contractor that specifically refers to this law and says, contractor agrees that it assumes all liability that the company may incur under Labor Code 2810.3. So having an indemnification clause is one step, if it's possible. The other recommendation is that you have an arrangement and agreement that you can audit. You can look at the practices. That you can ask them for some explanation and affirmation of how they comply with wage and hour law in California. You ask for some assurance that they have appropriate workers' comp coverage that covers the workers who they're putting on your property. If you have something posted on your place of business that informs the workers who come and work on your premises that if they have any concerns about whether they've been paid properly, they can come to you and you will help resolve those. Does that provide you any defense? It doesn't provide you a defense to the law because you have strict liability under the law. So if that person wasn't paid properly, you're liable for it regardless. But it is going to help you resolve the dispute before it goes to the GLSC, before the employee goes and files a wage claim. The question is, you have a vineyard manager who you have an independent contractor relationship with. And that vineyard manager is responsible for hiring your contract workers and entering into the contract with your labor contractor to have the laborers on your property doing the work. If the vineyard manager, who is an independent contractor, has his own business presumably, makes that decision, are you still responsible for the liability of those workers who your vineyard manager brings onto your property? And the answer is yes. You're going to be held liable for that. So I understand now it adds a new layer of what conversations you need to have with your vineyard manager about how they're managing it. But yeah, you have to be. You're accountable for the decisions that are made, the hirings that are made on your property. The question is, so already you get a piece of paper that says that the labor contractor has appropriate insurance and they're appropriately licensed to do what they do. And your question was, am I telling you that you need to get another piece of paper that says that they're also complying with the wage and hour laws?
Yes.
Right? So that's a good step, but it isn't going to, and this is where the concept of strict liability comes into play. And that's why the recommendation is that you have it in your contract, which I would say is the same as having that piece of paper, that they both confirm that they are complying with the appropriate employment laws in California, that they will indemnify you if there are any violations of those laws. But then there's another step to that, if you want to be as conservative as possible. And that is, you need to take some step to audit the practices and make sure that they're actually providing it. Now, so that's what the law would seem to require. You all have to make a business decision about what's practical.
So can I just introduce another thought here? I've noticed the direction of the conversation is basically towards wage and salary and liabilities there, which is largely invisible to us as the farmer. We don't know what practices might or might not be handled by the labor contractor. But one thing that is right in your backyard, right? I mean, right in front of you, are safety and health issues. Okay? Do the people that are coming on your property, are they properly trained? Are you giving them equipment, or are they being provided with equipment that's safe and functional? Are you supplying them with equipment that's safe? Do they have all the personal protective equipment? Are they following the shade standards? These are also immediate and real compliance issues that you have to deal with, that you can't say, well, gee, I don't know what the practice is where I have to audit it. That's a harder bullet to dodge, because a lot of that is specifically under your control.
So the point of this law, and it sounds really like, and I don't think this is new, but the labor contractor has to have workers' comp insurance coverage for their employees. That's always been the law. If you're an employer, you have to have workers' comp insurance coverage. And any labor contractor or staffing agency is going to have that coverage. So if somebody gets injured on your property, and it's during work hours, then you are tendering that to the workers' comp insurance coverage of the labor contractor. One of the issues, and I think the issue that Mike is pointing out here, is that if you have an OSHA violation or safety violation on your property, there's nothing that prevents OSHA from coming on your property and evaluating whether or not you have been providing appropriate personal protective equipment for the workers, whether the workplace, the work location is safe, those sorts of issues. And one of the things that this law says is you can't delegate the liability or the responsibility for that to the labor contractor. I don't know that that's really that new either. If you have workers coming on your property, if you have employees, you've always been responsible for complying with OSHA laws. So I think your second question that you were asking was what do you do when you're faced with a claim and you've got to go back and try to establish how many hours this person worked on your property, worked with you, how many hours they worked with somebody else. Because I'll tell you that when this worker goes to the DLSE and they make a claim that they were not paid overtime for the entire harvest period, they're probably going to list not only the labor contractor they worked with, but every vineyard they worked on. And so it's going to put the vineyards in a position of having to try to identify, well, this person only worked for me for these number of days, and I would only be liable for those specific days. Your final solution was whether you just turn it over to your attorney or somebody else to sort it out. I think this again goes back to your relationship with the labor contractor and what is the labor contractor doing to track who's on your property at any given time. Whether they're, I mean, somewhere you're going to have some records to establish whether somebody was worked on your property or not. And that's, I think that, you know, again, this comes down to the conflict between the law and practical operational realities. And how you manage that is a business decision you're going to have to figure out, and I think you partner with your labor contractor. Here's the thing about independent contractors. The risk is different than other areas of employment law because you have more than just one agency or more than just one area of law that's concerned about it. You've got the DLSE, which is the Wage and Hour Enforcement Agency. You've got plaintiff's attorneys. Okay, we got that in most areas of employment law. But then you've also got the taxation agency. You've got the FTD who's concerned about whether or not it's getting its taxes. You've got the IRS who's concerned about payroll taxes. And the EDD who's concerned about taxes in California as well. Then you've got the National Labor Relations Board who's concerned about whether these people are employees or independent contractors. So you've got a lot of different agencies that are interested in whether you have your independent contractor properly classified. I'm not going to go through all of the factors unless you really want me to read all 11 factors. Trying to establish that somebody is properly classified as an independent contractor is extremely difficult. You hire a plumber to come on and fix the bathroom on your property, they're an independent contractor. You hire somebody to come on and do, basically do the work that you do to pick grapes, they're probably not an independent contractor. You're bringing them on through a labor contractor, that's different. But the point is that independent contractors are people who have their own business. You exercise almost no control over how they do their work. They come on your property to do a specific task for a limited period of time. You pay them, and they decide how they do the work. They have their own business license. They have their own insurance. They are their own business, and they come on your property to perform work. That's an independent contractor. And too often, businesses in California try to bring workers on as independent contractors who really should be classified as employees. Again, it comes down to a business decision. I've worked with plenty of small employers who have said, look, I have these independent contractors come on. Sure, maybe they're not properly classified, but they don't want to be employees of me, and I don't want to pay them as employees, so I'm going to assume the risk. That's absolutely every employer's right to make that decision. But I just take a look at some point at the 11 factors here and recognize that trying to establish that somebody's an independent contractor is very difficult to do. And if you have independent contractors, you should take a look at them and make sure that you're confident that they fall within the limitations that we're talking about here. Happy to answer any questions about that, but I'm also happy to let you get to your dinner.